Anna, Mary, thank you very much for joining us and being part of this. And this is a presentation that we created called Turning the Mediator into a Visual Learner. And we presented this at the ALC conference not too long ago and wanted to show everyone a little bit about the slides that we did and created. And actually, before we even get started, Anna, tell me a little bit about yourself, your career, what you do.
Oh, sure. So I am an attorney by trade. I started out working in the medical malpractice space as a defense counsel, and then I transitioned to the in-house side of things and became and worked for a variety of different insurance companies, third-party administrators, and one of the largest risk retention groups in the country as of most recently. And for the last couple of months, I've been putting together resources to kick off my own consultancy called Berent Claim Strategies.
All right. Thanks, Anna. And Mary?
I'm Mary Martin. I'm a structured settlement broker. I've been in the structured settlement industry for more than 20 years, attending hundreds of mediations and seeing so often how we communicate with damages, with the mediator, with opposing counsel during a mediation, and just been so excited to be able to up our game with this presentation and the concepts that we're going to talk about today.
Great. All right. Well, let's go in the first slides here. Anna, lead us off here.
Sure, I'll kick it off. So the idea behind this presentation really was sort of grounded in the fact that we are so used to visual representations of ideas and data, and we're kind of heavily inundated with those concepts pretty much everywhere, whether it's a business presentation, like a social media reel, news, etc. And most relevant to us, we're now seeing it more and more prevalently in the jury trials. As you can't essentially step into the courtroom for a jury trial if you do not have a visual aid, a visual PowerPoint, or something that the jury can grab onto. So Mary, Noah, and I decided to apply the same type of concept to our conversations with a mediator. And of a special interest to us were conversations and some level of education for a mediator involving damages valuations and offers and making offers. And so we kind of went into a little bit of a theory here. So like, what is visual learning? And essentially the basic definition of it is, being able to process, retain information through visual cues. And that would ultimately allow the receiver of the information to understand more complex ideas, data, and concepts much easier.
Sure.
And it's especially convenient and interesting when you have complex relationships between ideas. So if you're demonstrating time and money, or you're demonstrating, several ideas together, and you want to convey them most effectively, visual narrative is the place to do it.
So tell us a little bit. We're going to go through the truths about jurors and mediators.
Oh, right. So the idea in sort of the analysis that as my background is in medical malpractice claims management, and I was a trial attorney earlier in my career as well, and a prosecutor. So this idea of appealing to a jury versus appealing to a mediator was something that needed to be parsed out a little bit more. And so, the level of persuasion that goes into educating a jury and having them become fact finders and confident and persuaded in the decision is very different, and sort of involves quite different visuals, right? We have to be a little bit more direct. We have to be more simplistic on some level. And we also are very cognizant of the generational differences. As we know, Gen Zs are much more used to, seeing visuals and having that be as part of their sort of narrative for education. And even though older generations are probably equally as interested in and used to being exposed to visuals, they're just not as well versed. And so that's one of the differences with the mediators in terms of generationally. But I think you can actually skip to the next slide.
Well, this is where, the story that I told was when recently in the case we were talking about an expert with two different attorneys. One was a more senior of counsel attorney, and the other one was a new first year working for a law firm, talking about this one expert. Older attorney mentions that, uses the idiom of, oh yeah, well, that's the expert that is like the little Dutch boy that put his finger in the dike. And, of course you got the associate that's like, what are you talking about? And so maybe older generations will understand some of those sayings. Younger attorney, new associate, replies back, well, I don't know, but I think that this expert is sus and completely lacks riz, no cap. And it's really interesting to see the generational differences now as we're getting more Gen Z coming into the legal field, and how you see the two different paths cross between it. Just more reason why visuals are important, so that way we can keep both generations on the same page.
I totally agree. I mean, I think this old adage or idiom, pictures worth 1,000 words, cannot be truer in this context, especially when you have so many generations and serving in our jury pools. But the mediators have a slightly different role. Generally, they're not fact finders. They're instead very much focused on trying to resolve cases. And as I mentioned, by virtue of their sort of educational and career heft that they bring into a mediation, especially in the medical malpractice context, which usually involves some pretty difficult ideas to parse through, understand, etc. They tend to be older. They tend to be Gen Xers. They tend to be baby boomers. And they're not used to, I mean, just, sort of generalizing here, but they're not used to being appealed to visually. And they have a very limited time. And so, and they're, it's not necessarily because they might not be good at it, or that's not the way they learn. It's more of just, that's not something that they've been exposed to. And so we wanted to test that assumption a little bit and see what we can come up with as far as the visuals, to be able to anchor them and persuade them and strategically equip them to understand our offer and what we bring to the mediators table at the outset.
Moving forward, let's say we start providing more visual aids. And I know that several attorneys have told me that they used to do PowerPoints or some type of presentations to attorneys, or to mediators, but in doing kind of like a clopening per se, opening, closing presentation, but they've come away from doing that. In some ways, it seems like we're almost suggesting that we go back to what do you think will be the difference?
I can start off, and Mary, I know I'm sure you have stuff to add. I think a PowerPoint presentation is different from a PowerPoint presentation is different from a PowerPoint presentation. I think it really just is about what you're trying to capture and what the purpose of your visuals ultimately is, right? It's, as Mary mentioned, a brief is a brief, and, some mediators would prefer it no matter what, but a PowerPoint presentation has to be a concise visual representation of not just the facts, but where you see your case going for the sake of the mediator. So it's with the idea that now that you've educated your mediator during a pre-call or during, an opening statement, that PowerPoint and those data points, visuals, etc., are now going to go back to the plaintiff and the plaintiff's room, where they're going to be thinking about and marinating in the information that's provided to them. And I think that's far more, we never share mediator briefs to the mediator. That's always, confidential. But when you're presenting a PowerPoint, you understand that those visuals are ultimately going to be shared with, or at least you hope that they will be shared with, the opposing counsel and their client. So that's where I see the advantage of this. And I'm sure, Mary, you'll probably add some more as well.
Yeah, I think it's an incredible opportunity to be concise, to present your view of the case, and to walk in creating the understanding that you're here to negotiate, you're here in good faith, and that your offer has considered the plaintiff's needs and really sought to address the damages as you see them. And I think that's a huge distinction from reading off, reading the slides of a PowerPoint that summarizes the brief, where although the mediator, sort of as we talked about, isn't a fact finder at this point, we are sort of aiming to garner goodwill with the mediator and goodwill with the plaintiff by presenting ourselves as a reasonable, good faith negotiator.
I was just going to add one, sort of logistically, a lot of mediations now, especially after the pandemic, are being done virtually, right? So you have everyone as captive audience in front of the screen. So why not take advantage of, having something on the screen that's going to capture your audience, and, not just your face, not just your oratory skills, but an actual visual representation of how you see the case in the most persuasive way possible.
I think that a lot of the PowerPoints that were done before were exactly that, the older type, lots of bullet points. And just because you're showing a bunch of bullet points doesn't mean you're actually visually showing something more than what is in a brief. And I think that, the development and of visuals as things that progress is definitely different as we're starting to think in terms of reels instead of stories. One of the questions that I was just thinking about, though, is how often do you think, or actually, let me rephrase this, if you provide some of like the damages, a life care plan type of graphics that we have to a mediator and show them, what's the obligation of that other plaintiff attorney to show their client?
I'll take that one. That's challenging. It can be pushing the rock up the mountain to try to get them to show material to their client. They don't necessarily want to do it with damages analysis, with structural offers, in part because they're such powerful tools, then they can have such a positive impact on the plaintiff, whereas the attorney would rather sort of keep the perceived negotiating power by focusing on a cash number, keeping in mind, where he knows his client wants to end up, and not having a needs-based analysis of the damages, right? So we're all focused theoretically on the damages making plaintiff whole, but in today's environment, are we really talking about damages doing much more than that? And so re-anchoring back to plaintiff's future needs and how we're going to address them with a offer that may not be what plaintiff attorney wants to hear. It's hard to get them to take that to the plaintiff. If you've done a good job anchoring the mediator and made a good impression on the mediator and put a compelling information in front of the mediator, it may be easier to have the mediator, to convince the mediator to apply a little bit of pressure, to really take that into the other room and ask the plaintiff directly see it. And we've seen that be successful, particularly maybe in later stages of a mediation, but it's hard. When we look at, some of the visuals that we're going to present a little bit later, and you imagine yourself as the mother or the father of the little girl we're going to talk about, seeing what this offer would do for her over her lifetime is really powerful.
That's great.
I would also add, and I think, Mary, you, in the course of our conversations, on this topic. You mentioned that there is, in fact, the duty that a plaintiff's attorney has to explain and present a structure offer if, in fact, it was made by the defense side. And I can't remember which case it was that you referenced where there was, in fact, the finding of professional negligence by a plaintiff's counsel when they neglected to do it and the plaintiff ended up running through the cash that they were, that they ultimately settled for and accepted, right? Did I get that right?
This was a minor's case, and the minor had long-term medical needs, and plaintiff's counsel did not share structure offers that the defense made. And those structure offers would have protected against dissipation and provided these guaranteed funds over lifetime. And instead, the child's parent took cash. And as is extremely common, even for financially savvy plaintiffs, that the rate at which that cash dissipates is so fast. And so the plaintiff came back to the plaintiff attorney concerned and ultimately discovered that structured settlement offers had been and eventually successfully collected against the plaintiff attorney's malpractice carrier for perhaps not the full difference between the cash and what the structure would have paid, but made a significant recovery on the basis that plaintiff's counsel had a duty to share that also with his client.
That's great. Let's move on to the next parts here. This is a graphic showing the attention span of a goldfish being 9 seconds. And I believe the attention span of a human now is between 5 to 7 seconds, as this graphic's just a tad bit older. One of the things, examples that I like to use, usually I use this with dogs, but in medical malpractice cases, I love this example of, everyone who's listening or watching this, think of a chicken and, what would a chicken look like? What color are they? Are they big? Are they small? Is it a rooster? I don't know. And then I show another picture of Nick Rowley, plaintiff attorney, great attorney, that in his chicken suit on a case that he is. And the point of this being is that oftentimes jurors, mediators, everyone as a whole, when we are told something verbally about an idea, maybe a medical term, a process, or a surgery, that we might have different ideas of what that actually looks like. And it's not until we actually show them visually that we can, as a community or a group, can all become on the same page. The example that we come across often is shoulder dystocia cases, and be able to show, instead of just the doctor testifying about the various different maneuvers, McRoberts maneuver, suprapubic pressure, to relieve the shoulder, internal rotation, to actually show the various different steps one by one, helped everyone really understand what happened. Complex things is maternal fetal circulation. My gosh, ask any male that's 18 years older, that actually, how does this all work? What does a placenta do? Do you know what a placenta even is? You'd be surprised, but unless they've taken some types of anatomy classes, they might not understand. And so creating something like an animation or an illustration that goes through this helps. It more so having graphics that can be, and I know a lot of people have stayed away from this. Some people have stuck with it, but having foam core boards and bring those up in court. I love having an expert that might be better testifying and basically teaching on their feet to be able to draw on it and interact with a visual as well in front of a jury. Now, I know that most medical malpractice attorneys have worked on a series of different types of cases, but they probably haven't worked on every single type that has ever come across their desk. And we get some unique ones. Every other day I'll receive a new case. And I've worked on over 5,000 of these, and I'll get something. I'm like, I've never heard about that before. And even I have to do my own research to get up to speed. I think defense attorneys, as well as even, mediators that do medical malpractice, they're not going to come across every single type of case. So there might be some where we need to still explain the medicine and what actually happened. And that's where graphics like this happen and come in. Another example is taking something like this and having a plaintiff who is angry because of what happened, whatever medical complication that happened that they brought the case for, that maybe they didn't truly understand what actually happened medically and the reasons why. And sometimes it's just knowing the reasons why that helps bring some type of closure to them. So us being able to show those visuals from the defense side can be really helpful. This is Allison, and this is kind of what we based our example moving forward on, showing examples of a brachial plexus injury and showing the positive side of the demonstratives of all the things that are normal, everything that is fine with that plaintiff, showing various different silhouettes based on the expert testimony or was it the IMEs that are done to show, they're homeschooling, they're talking, nurturing, they're happy, excited to be around, they're playing piano, they can get out in bed by themselves, brush their own teeth. And so showing a series of silhouettes helps bring that positive side early on in maybe mediation. Maybe a lot of these are probably saved for an actual jury trial.
I mean, these also provide a very succinct summary of where defense sees the damages or maybe potentially sees continuing damages and where the child in fact has recovered. And that is to me, that's a powerful representation even for a mediator to see, all right, this kid is able to do X, Y, and Z, but these are the challenges that this child is still having. So that's where the plaintiff is likely to focus on. And that one slide is worth probably a page and a half worth of a mediation brief describing exactly what a physical therapist said, exactly what an IEP said, exactly how well the child is doing at school, et cetera, et cetera, et cetera.
So these are the next part, the process that we want to show. Mary, do you want to start with this group and go through them as we go?
Yeah, so I'll jump in. When we have a case like Allison that comes to us as structured settlement brokers, we will typically receive the plaintiff's life care plan, medical reports, and if one has been prepared, the defense life care plan, or at least maybe their experts' comments on plaintiff's life care. And so part of what we want to do is look at that and do a couple things. First, make it more understandable and easy to compare. When you're looking at 220+ page life care plans, each of which is in a different format with different wording for categories, with categories in different order, it makes it really hard to compare them side by side. So the first thing we do is just put them both side by side in a spreadsheet so that they're easier for us to look at and evaluate ahead of mediation. This is a really dense spreadsheet. It's not helpful necessarily or impactful to show to a mediator during the mediation. So it provides great information. What we've got is then turn it into an offer and turn it into something that's going to make an impact. And so how we do that is we compare the specific items that each life care plan calls for and turn those into an annuity benefit. So making payments over time when the need begins. So we might have a child like Allison who needs different types of physical and occupational therapy at different ages. So we tailor all of those benefits specifically to what that child needs. And that helps us determine a cost that it would take to fund that life care plan. And so if we go to the next slide, I think that it will show us what it might look like when we do our side-by-side comparison.
Right before we do that, let me ask you a couple questions here. Life care plan, that term that's been thrown out, it's caused some controversy amongst various different people. I believe that the defense bar has said, why don't we change it, instead of using life care plan, let's change it to medical necessities. What are your thoughts on that?
I think that starting from the beginning, there's a lot of questions about life care planning as a science. foreigner, and the ability to predict these needs later in life, and the inflation that we can see when suddenly more and more and more cases are calling for future 24/7 care and these really extensive damages categories. I myself, I like the idea of emphasizing, as we emphasize with Allison, what she can do. I like the idea of emphasizing how we're going to take care of you medically over your life versus the slightly different emphasis on here's all the needs and all the problems you're going to have over your life. So I think that there's a little bit of a back and forth we can think about as some tension between those two ideas. You know, I'm frequently seeing life care plans that include things like case management and educational support and other things that really transportation that wrap around providing a sense of security that is going to be able to meet those medical needs and have an idea of what's going to be there for them in future. It may take away some fear.
I would also add, that just because a plaintiff has produced the life care plan as a document themselves, it doesn't necessarily oblige defense counsel to produce their life care plan as a document with a separate expert. Because that data is contained in the plaintiff or in the child's chart, existing records, past records, opinions in terms of, economic damages and losses and things of that, maybe even an IME. So a life care plan as a concept, I think, is sort of understandable and can easily be grasped. And I agree with Mary, sort of its questionable origin, sort of keeps reiterating, it's a recurring theme really because of sort of the crazy numbers that we're seeing on the other side of the V with these. But as a concept is one where on the defense side, we understand what the child's needs are, as in this case, and how we can fulfill those needs going forward.
For life care plans, for someone who might not be familiar with, both sides typically create one, correct? Or is it usually just one side?
Yes.
And how, if one side's creating it, is the other side reviewing that before they create theirs? So for instance, if plaintiff created theirs, are we then taking that, reviewing it, and then hiring an expert to review and come up with our thoughts based on theirs and to compare, or like apples to apples, or are we kind of both putting in our own piece and comparing it from there?
It's done every which way. And I think you're tapping into some of the conversations that we on the defense side and the claims management side are having internally about this concept of life care plans. And like I said, sort of the old school way of doing it was, well, I can't do anything unless I know what the plaintiff's plan is. So I can't hire somebody to, start creating a life care plan on my own, without looking at what the plaintiff has to offer. And I think, that sort of way of thinking has been sort of slowly transitioning to, no, we don't need to wait for their plan because we have the benefit of reviewing the medical records. We have the benefit of looking at the, school plans or, evaluations by neurologists, et cetera, whether it's, again, contained in one document as a summary or whether it's contained in bits and pieces of the records, and then either defense counsel or damages counsel is able to consolidate it into one solid document and ultimately then work with a structural broker about making an offer. That's a sort of like a newer way of doing things, in my opinion.
Okay.
I don't know if that answered your question, but
Yeah. All right, Mary, let's look at this slide comparing life care plans. Tell us about it.
This might be distilled from two 20-page documents, right? And so whether they sort of, and as Anna said, we would see this come from two ways. The defense may have prepared their own plan, which represents their own assessments of what plaintiff is likely to require medically, or they may have started with plaintiff's plan and said, well, we disagree that this is needed. We agree that this is needed, or we agree that this is needed, but it costs less per item, or it's needed less frequently or for fewer use. So you'll see all of these little nuances. And what we'll do is go through and identify these areas of agreement and areas of disagreement. And this can be really helpful to, when the areas of disagreement are relatively small, anchor the reasonability of our view of the life care plan. It can be used to provide, sometimes we just have one damages category that's wild discrepancy. And so we can talk about how we're going to address that specific damages item, that specific medical need, without, just sitting back and saying, well, this plan is inflated. We've got, one item that we're disagreeing on, two items that we're disagreeing on, but we may have a general consensus. And so I think being able to visually represent clearly what's needed and then clearly where the areas of general disagreement or general agreement are is sort of a helpful way. Again, I could see using this during a mediation because it's going to be ultimately used to ground and inform what those settlement offers are going to be, what types of instructions are going to be offered. And I think that is a better way of communicating about that future medical need, again, than is, a brief that has six or seven paragraphs on the life care plan.
I would also say, before AI started, taking minutes in meetings, the old expression was the most powerful person in the room was the person who takes notes. And these two slides to me is exactly that, because you have the power, if you're presenting this information to the mediator, you have the power to have been able to synthesize it in a concise way so that the mediator sees where the biggest discrepancies are. And you're also the one who compiled the data, as Mary said, into specific categories that in many ways might also be done in a way that's advantageous to showcase certain things and maybe downplay other things.
So this is a Venn diagram. It's very similar to the last one, just a different style. One of the things that some people might notice is that oftentimes you think of defense will be green or blue, and then the plaintiffs are going to be orange or red. That's not what we're trying to get across in this one. We have more of a purple type of tone visually, because we're not attacking. And then, the plaintiffs on this case, we're trying to collaborate with them to come to an agreement. And so especially since these slides might end up going to them directly, it doesn't look like we're attacking them in any way. Just to give you a couple different ideas of what we're trying to do and accomplish visually. So what is an annuity? Let's go through this process.
Yeah. So many friends we may step into a mediator is very familiar with them. Sometimes we won't. Sometimes we'll speak with a mediator who knows about them but doesn't know how to negotiate with them. And, as we talked about earlier, we really want some of this information to be able to make its way to plaintiff. And so one of the things I've heard from a few people since our presentation of ALC is that structured settlement brokers could do a much better job of presenting information in ways that plaintiffs can understand and plaintiffs can connect to. And so I think when we make these color choices and these graphics to visually represent it to plaintiff, again, I think one of the things we can do to garner whatever goodwill could be available is to speak to the plaintiff and reduce their uncertainty, to give them a sense of confidence in some way. And so in a structured settlement annuity, rather than paying plaintiff the lump sum up front at settlement, we'll pay a portion that way for attorney fees and any other immediate needs, but then use a portion also to purchase an annuity So guaranteed payments from an outside insurance company, a life insurance company that's highly rated. And that company will then pay that annuity to plaintiff over their time. So that annuity that may have an upfront cost of $1 million is going to pay plaintiff over her lifetime $5 million. And that's $5 million that's guaranteed. If the stock market crashes, plaintiff doesn't lose all their money. It's money that's tax-free because it's damages. It's not treated as income. And so we really want to do a good job in every way that we can to present some value of that to plaintiffs, because it's a once-in-a-lifetime offer. While we can all go and buy, a retail annuity as a retirement investment, nobody can go and buy a structured settlement other than the defendant or insurer in a personal injury claim. And that's the only time it's available. So when we spoke about the malpractice claim in Texas, later, after the fact, you can't go back and get it. So this communication that we can do during the mediation, both with the mediator and if we're able to with plaintiff, is really valuable.
Yeah. What happens if a plaintiff passes?
So it's almost the most common question we get when we provide our simple black and white spreadsheet proposals that I think we're just so much upgrading in the discussion we're having today, is plaintiffs want to know, is somebody going to get a windfall? What happens if I get hit by a truck on my way home from this mediation? And part of our professional responsibility is making sure that can happen. So we'll typically have a combination of guaranteed yield, which means money that's paid regardless of whether plaintiff is living. If you do get hit by that bus on the way home, your children or your spouse or whoever you designate will receive that money. And they'll also receive it tax-free. So that prevents anybody from getting a windfall, right? And then also we'll pay lifetime benefits. And that portion of the benefits will continue as long as the plaintiff lives. And that plaintiff could be a record breaker and live to 125 years, and still those payments will keep coming. We'll always provide an estimation based on, here we've said 86, which for Allison would be her normal life expectancy to age 86. So we'll provide an estimation, illustrate for the plaintiff what that means. But I think it's important to always emphasize that's going to go on forever. There is no way you will run out of money. You will always have this there for you. And that provides a lot of certainty and confidence going forward.
I was also going to add, with respect to, since we broached the topic of age and death and sudden death and whatnot, and I think, Mary, you brought it up initially, and it was really eye-opening, that discussions of rated ages and discussions of, life expectancies in the context of offering an annuity, it makes defense, takes the sting out of the conversations about life expectancy. And I would hope allows the mediator to side more with the defense if we're not competing with the plaintiff about how much life expectancy a child or, any injured party actually has.
That's a really good point, and it's a fantastic opportunity, especially for cases, again, where you may have a child where you may have injuries that are really life expectancy affecting. For just to kind of go through it for somebody who might not have thought this out, but if you have a plaintiff that has high medical needs going forward after an accident, the longer the plaintiff lives, the more damages they have. And the shorter the plaintiff lives, the less damages, but economic damages. And so there's a necessity on the defense end to talk about what that life expectancy really is when evaluating what the cases were. But when you're sitting in a mediation, you do not learn a goodwill or the intention to come to an agreement if you're pointing out of the fact in your favor that this plaintiff is going to die much sooner than they otherwise would. We're trying to tell a parent that their child, in addition to having some injuries, is going to pass away early. And so we can sidestep that because the rated age allows us, who's better at pricing mortality than life insurance companies. So the rated age allows us to purchase an annuity at a cost that reflects the reduced life expectancy while still providing for prenups that even if that life expectancy isn't reduced, even if they continue to live, they will still have that. And so, Anna, like you said, it sidesteps what can be a really prickly emotional issue. And the more of those issues we can put to bed peacefully, I think the more we can step closer to a resolution.
And we can also show empathy to the mediator in understanding how difficult those conversations might be with the plaintiff's counsel and, and their family.
So next slides we have our cash flow build up included in monthly payment. What would you like to say about this slide?
Yeah, so this is really interesting to me because this is not, typically when we present structure offers now, each of these might be a simple line item, a monthly payment or an annual payment. But I love here the way we've done a few things. We've really used the icons to anchor folks to what it is we're providing. And it circles back to Allison and highlighting what Allison can do. Allison can own a home. Allison can be a homeowner and take care of the home. So we're going to support her in doing that. She's going to be able to have a home down payment, which is so difficult to achieve these days. We're going to help Allison with college. We're going to help Allison before college go to the best summer camps or have any supplemental education, opportunities that her parents might think are best for her. And so the way we see that build up over time is so much more valuable than it looks like, again, with a spreadsheet. I think when we walk in with a spreadsheet or we show a mediator, something like this, we're really highlighting again this message of what we can do, what we will provide, what will be there for Allison.
So I take it we have those icons. We do a transition to show, and on this slide, what I love about it is that on most Ben Mel cases, we'll have like what we call a circle of care. We'll have the plaintiff in the middle, and we'll show all the various different doctors, specialists, nurses that are taking care of, and we're taking care of that patient throughout their time in the hospital or as needed. This is kind of a way of showing all the various different ways that we're providing care to support Allison. This is just another way of showing the building up blocks.
Yeah, so I love that, and now I want to call this sort of a circle of economic security.
I love that.
A circle of economic protection. So we present the same damages that we talked about in the prior slide, where we talked about what each annual and monthly payment would be, and now we're going to show how much over for lifetime each of those is going to provide. So how much it's going to provide for her during her childhood to get all of these, the best summer camps, the best horseback riding lessons, or whatever might be helpful and beneficial and fun for Allison. We're really emphasizing she's going to have $50,000 for college. It's going to pay up $3 million over her lifetime for medical. So I love this circle of economic protection.
So cash versus annuity. What's the point of this graphic here?
So this is a great way to sort of simplify and boil it down for plaintiffs. Plaintiffs walk into a mediation often not knowing very much about structured settlements. Anything they may know about structured settlements has come in the form of like a singing Viking from TV. And so we want them to understand that this isn't an arrangement to simply allow the defendant to pay damages over time. This is an arrangement where we are going to solve a lot of the problems that an all-cash settlement would have. And so when that plaintiff walks out with an upfront settlement, they have to invest it. They have to invest it in securely, but they also want growth, and they will pay taxes on their investment. Whereas with their structured settlement, it will go tax-free. The statistics for depletion of funds for people who have personal injury settlements are about equal to depletion of funds for lottery winners. These are damages that we're paying that are intended to provide for damages and needs that a client may have over a long period of time, maybe the rest of their life. And so if those damages are going to be depleted, if 90% of people have no money left after 5 years, how are they then going to meet those needs going forward? And whereas the structured settlement, like we said, it provides this guaranteed income. When we pay it for life, it can't be outlived. It's not going anywhere. And it's got all this built-in protection from depletion, dissipation. And plaintiffs don't have to make decisions about how to manage it. It's a guaranteed interest rate that's going to pay out to them on exactly the schedule that they agree to. This means a lot of great things. This means they're not paying percents every year on money management fees. They're not paying taxes. Their second cousin's uncle stops by. I heard you received a significant settlement. Can you help me out with surgery for my dog or whatever it is? And that's something that happens to plaintiffs a lot. They receive a cash settlement and everybody in the family shows up with a problem, a financial problem they'd like that person to solve, not necessarily understanding that this money needs to last a lifetime. And that's one of the factors that gets us that risk of depletion. So when the money is in a structured settlement, cousin Bob can't have anything. It's paid out to me over time. I don't have money for the surgery to give to you. Meanwhile, you're getting regular payments to meet all of your needs, but not sitting there trying to figure out how to manage $1 million of investment.
When it says that it's guaranteed monthly income, what if, does that mean that, let's say we set it up through a certain group, what if that group goes under?
That's a really good point. So one of the things to know is that the life companies that underwrite structured settlements are the top life insurance companies in the world. And so life insurance in general is very secure. And we have outside unbiased ratings agencies that assign financial security ratings to each of them. We've all probably heard of S&P ratings or AM Best. So we're talking about life insurance companies that have the absolute top tier of those ratings, have to post reserves based on the claims that will ultimately have to pay. And then we also have levels of protection. So there will be often an irrevocable guarantee from a second entity to continue to make those payments. And then in many states, there are different levels of state guarantees that operate similar to the FDIC for bank accounts. So when we place this money for a plaintiff in a life insurance company, think about New York Life Insurance Company or MetLife or Prudential, these companies that have been here and been stable for decades or over 100 years. And so that level of security remains higher than funds placed in the stock market or with a financial planner, or even in a bank account, because if you're taking $1 million of lump sum and you put it in a bank account, you only have FDIC protection for the first $250,000. That guarantee is really backed by titans of the financial industry in terms of conservative investments and guarantees that they'll pay and they promise to pay.
That's great. And this, even if one company is, merged with another, everything still stays the same.
Yeah. So we have seen that happen, and that's exactly how it's proceeded. Clients have just continued to get their payments from the new entity.
If anyone's seen and noticed on this slide, we're showing a comparison. We're also showing a lump sum, like a bag of money, versus a plant that's growing. And on this example, we're showing how it's 1.5 times guaranteed return, 5 times potential return over life. So the delta. Here we have an example of plaintiff demands $7 million. We're offering 1.5 for a cash and annuity. A Apparently there's a delta between there. Why would someone as a plaintiff want to take this option on the right?
Yeah, absolutely. So, we're never going to start out very close in our offers and demands. And there's always going to be some level of delta there. But when we're negotiating through a structure and we're providing these long-term benefits, we have to look not just at the upfront cost. So that's the investment amount or the principal, the $1.5 million, but what that is going to provide over a lifetime. So that's how we can use these graphics to illustrate to players the way that offer, that purchase of the county annuity is actually then here's what it will pay out in this example over their lifetime, which means the spread, that delta in terms of what we're providing is really much closer to that $7 million demand. When we provide this, the simple spreadsheets that we provide now, I wish I had one in here to show. They're very simplistic and, they'll show this cost and they'll show the guaranteed benefit of the annuity. But this side-by-side comparison, I think, is so powerful and really something that we would want plaintiffs to see really how close this is coming.
And no, as you can see, like in this particular slide, it's really all about the plaintiff and the defense, right? The plaintiff's attorney's fees are not included in here. And even though they're always a subject of conversation, especially in, in some of the negotiations with larger numbers, this is a slide directly for the mediator to understand what this offer can do for the plaintiff and nothing else. And so any kind of sort of retort from a plaintiff's counsel, such as, don't worry about it, take the sum, we can put the money somewhere, we can invest it for you, or ultimately is going to come out showing that there's a little bit of I hate to acknowledge, but a little bit of a self-interested part of here. And we specifically did not include that on this slide.
I think very much, the amount the plaintiff is going to pay in fees is a conversation that we will generally do better not to represent in our offer and not to encourage plaintiffs to see that as something they need on top of the damages, which I'm seeing sometimes. So by focusing on what the demand and what the offer is, and then here's what the offer really is in terms of providing, I think, is a cleaner way to do it.
If I was a plaintiff and I saw something like this, why would I choose this when I could say, well, I'll take the 7 million and that's what I want. And then I'll put that in an annuity and I get 7 times more. What's the argument to that?
And what sorry, no, go on. So and this is where that early education to the plaintiff about the structure and to the mediator, because we had plaintiffs say that. We sometimes have mediators say that as well. Let them go buy, an annuity after the fact. They can't. So they can only obtain this structured settlement with these tax-free benefits by negotiating with us and resolving the case with us. They can't necessarily obtain it after trial if they get a verdict and then it, goes through appeals and they ultimately get paid. It will typically be too late. They can't go out and purchase that guaranteed income. They can go and purchase a retail annuity, sure, but they're going to pay tax on the portion of that benefit that represents income, which means that $7 million isn't going to turn into as much as they imagine in their mind. And, even when we get a little closer in the cost level of the numbers, anything they spend on an annuity that they go buy after the fact just isn't going to provide them as much. They'll never be able to reach those benefits.
When,
that, the delta between 1.5 and 7 is there for a reason. And the reason is our valuation of the case is at 1.5, and, the plaintiff demand is where the plaintiff's demand is. So what that ultimately results in is this gap, right? This delta that we have that's sort of unbridgeable. And so what happens? Then more time passes, maybe another unsuccessful mediation, maybe, additional trial practice, motion practice. And all of that is essentially time. And time is not beneficial for the defense, and time is not beneficial for plaintiffs most of the time. Just because the demand is there doesn't mean, that our job is to meet it. Right. So, we're never going to be like, all right, we'll acquiesce and we'll just give you whatever it is that you're demanding. So there's always going to be a negotiation. And the question is, what's that zone of uncomfortableness that we all agree on, and that an annuity could be one of those.
moving into lifetime financial security provided by annuity.
So this is sort of another way of looking at that circle of economic support, particularly with an emphasis that this is going to go on forever, right? That cash lump sum gets that this goes on forever, all the way through the end of Allison's life. And so we're really going to emphasize all of what's included in that circle of economic care. Got education support, college, medical needs, home down payment. There can be all different kinds of payment streams we can create. We're not limited to these categories, right? These are example categories. But once we can get a little bit of a conversation with plaintiff, a little bit of an insight to who they are, we can often really figure out what's going to motivate them. I've seen death cases where the big fear that the surviving parent might have had is how their kids are going to get health insurance, that would have been provided by the other parent's employment. And we have all of these unique things that plaintiffs want to achieve, ways that they envision their life or their child's life working. I sit with a lot of parents of injured children, and they have so many different opinions about how they want this money to provide to their children. But they recognize and appreciate that it's providing their kids with security over their entire life that will take care of that child financially when the parents no longer can. And I think that provides a sense of relief or confidence for plaintiffs, or at least demonstrates our empathy and compassion and care and good faith.
For those that end up, they want to settle during this mediation, do they ever have kind of like non-economic damages that are separate to where they can set up an annuity, but they also get a lump sum of cash up front?
Yeah, so typically that's most often what we do, other than, for example, for minors who can't really receive cash. If they really need it, it can be put in a blocked account or a trust. But let's talk about adults. Adults will often have been out of work for some time, have some challenges that they need to address after settlement. And so we need to be thoughtful in providing them some upfront funds for that. Now, as long as the damage flows from the physical injury, all that can be economic damages, non-economic damages, loss of consortium, all those different damages types can be structured as long as it flows from a physical injury. And so we'll typically look at how much they might need up front. They might need to buy a home. They might need to relocate closer to medical treatment. They might need to buy a vehicle that can accommodate a mobility device. And we'll provide that for them along with, we want them to have some liquidity for as needs can come up. And usually fine tuning what the structure ultimately looks like is a discussion that can happen over some time after mediation while plaintiff agrees in principle to the concept, and then we work with them and really develop this circle of lifetime care for them. So we can assess for them what we think their needs are going to be and how we're going to address them. And then they can tell us, well, what I really need is, what I'm really concerned about is, and then we can create an annuity benefit that solves that for them.
What if they have a mountain of debt from medical, necessities, things that were needed, or, let's say they were under Medicaid and Medicare? Where does this all come into needing to pay them back?
Yeah, so I have an entire hour-long CLE course I could do on Medicaid and Medicare.
Great.
And how to satisfy those liens and how plaintiffs can go on after settlement and keep Medicare or Medicaid benefits, which is so incredibly valuable to them, and can be part of that lifetime circle of economic care. When we have liens, typically we'll see those liens, and those can be Medicare, Medicaid, hospital providers that they've been seeing. And sometimes they can be kind of litigation funding loans, that the plaintiffs have taken out in order to meet their needs. So those do typically get addressed up front. So when we work on that final number of what will be the cash component and what will be the annuity purchase component, we're going to take all of that into account.
Okay, thanks. So this next slide, understanding net present value.
One thing that we see from time to time, and I'm sure you've seen it, we've all run across it, is the plaintiff attorney chalkboarding damages in terms of future value without reducing to present value. It happens. And when we're aware of it, it creates a good conversation to have where the annuity costs may be closer to the present value of that offer. So if we received $500 in 1970 and invested it, that would yield us $4,142 today, based on these assumptions. And so when we're paying a plaintiff now for medical care, they're going to need over their entire lifetime, we pay them the present value of that, the amount that would be invested to provide for that in the future. And the structure is a really efficient method of determining present value. Present value is always calculated based on a series of assumptions, and we could have, I think, a whole additional presentation of that, how those calculations are made and what goes into it. But you look at then the rate of inflation and what investment earnings are available. And plaintiff and defense will always come up with a different number. But the annuity cost for a given future benefit doesn't rely on assumptions. It's a cost. You could write a check for that amount today and the life company will guarantee those future payments. And so when we're negotiating in terms of present value, we have to do a good job making sure that plaintiff and even the mediator understands that the present value isn't the delta, sort of like our previous slide, what it provides over time is.
And I would also add to that, the reason why we thought this concept specifically was of value to help the mediator understand exactly why an annuity is sort of a way to go or a better choice, is because plaintiffs themselves are often grounded in numbers by their counsel that are not discounted. So they literally take a cost and they multiply it out And, they're left with these multi-million-dollar numbers in their head, and they don't quite understand sort of the fallacy of even that logic. So if a mediator sees through that, they can ultimately impact the conveying of the offer to the plaintiff and to their family, sort of seeing where the pitfalls are for why they're seeing these like multi-million-dollar numbers without understanding that this actually needs to be discounted to net present value.
Go back to that. So here's a graphic where we're showing understanding net present value. We have the plaintiff's predicted annual salary over 10 years, and then the plaintiff's apparent demand and the true value.
And I'm so glad we included this because it highlights, what we would be providing by actually purchasing that, $60,000 a year with increasing, benefits for inflation. And we can provide that long-term yield at a lower cost. The other thing that we'll throw in is that because the structure is tax-free, we're actually providing additional value there. If the plaintiff was earning $60,000, what did they net after taxes? Well, if we provide $60,000 in the form of a structure, they net $60,000. And so we have a few different ways we can handle that. But I think it's helpful to understand and to make that distinction for plaintiffs, when we're trying to, and mediators, when we're conveying this information about present value, this built-in tax protection is invaluable as well.
So this is our last slide. Feel free to go over the points here.
Yeah. So this is fantastic because we'd use this as the last slide in our presentation. We could use it as the first slide in a presentation to level set expectations, or to just give the briefest thesis of what we're going to go into, what our approach is and our offer. But we're going to emphasize we're meeting the damages. We're paying for life as long as plaintiff is alive. Built into that is the idea that it's got that protection against dissipation, against depletion, so it's going to be there. Tax-free, we're saving plaintiffs headache after headache in terms of not having to handle taxes or the money management fees and selecting good money managers and so on and so forth. The highly rated life insurance companies, and that, for example, like we talked about, where a $60,000 a year income replacement structure is net as compared to a taxable salary, we can do better in some cases than what the plaintiff was actually netting or experiencing. We can provide a financial outcome for them that provides them more financial security. And one of the things I've said to many families when I had the opportunity to speak directly with plaintiffs is, there's no offer we can make at a mediation that's going to undo what happened. But we can make sure you don't have financial stress, that you always have funds for your care, and that those funds, when we look at Allison, provide for having, some of the best experiences that she could have as a child. So I think we always want to circle back to, and what a lot of the value of negotiating through the structure is to focus on that. We are here to meet plaintiffs' needs to satisfy these damages, not to create intergenerational wealth.
And the way to do that is by anchoring the mediator and having them understand what our offer exactly represents and why, so that because they have access to the plaintiff like we do not, and that we never would. And so that once they become a believer, once they understand what the stakes are, once they understand what it is that we're trying to do and try to do it thoughtfully with empathy, you know, it would create much more of a persuasive pitch to the plaintiff themselves in the long run.
I love this concept of anchoring. We know that the mediator is a neutral who's aiding both sides in reaching a resolution. But to the extent that we can anchor that mediator in the good faith, reasonableness, empathy, and appropriateness of our offer, and give them the vocabulary or the images to communicate that, I think we're helping our position immensely and helping the mediator do their, fulfill their role.
That's all we have, Noah.
Well, I want to say, is it any last thoughts, any last things you'd want to get across that if I was a mediator, or no, actually, let me say, if I was a defense attorney, what do you think I can expect to start using some of these visuals? What do you think I can expect in working on, my next 10 cases? Maybe that's a weird question. I could,
For starters, if you have a handful of, large damages cases that are going or slated for a mediation, I would get with your claims manager or like folks that work with the TPA for the insurance company and talk to them and talk through each and every one of these. And this is especially, I would say, this is especially relevant for cases where you have ongoing damages, ongoing, medical needs, regardless of how someone may be devastated slightly or devastated tremendously. But let's have a conversation, pick 5 cases, you as defense counsel, and let's set up a meeting and let's talk about which ones would really be, worthy of having an annuities type presentation and a damages presentation to the mediator, both prior to the mediation itself, so that you can anchor them, not just in the substance of the case and where you see liability or you don't see liability, but also with respect to the value and the damages as you see them. Mm-hmm. And then ultimately, transition that presentation to the plaintiff as you deem appropriate.
Would these types of graphics be helpful for every med mal defense mediation that's out there? Or is it going to be only for specific types? No, so that's a tough question, but I imagine that there might be some where people have to have a mediation, even though both parties agree there's no way we're going to settle this thing. Is it worth putting any effort into some of these?
Yes, absolutely.
As a structure broker, I'll always say, come prepared with a structure for every mediation. How you approach the structure in a given case and how much you are relying on it to anchor the mediator can vary by case. You may have cases where it's an absolute no-brainer. You may have cases, one thing I hear somewhat often is adjusters and defense attorneys can in some cases be hesitant to bring a structure broker or structure offers to a mediation because they feel that it sends plaintiff the signal that we're here to pay big money. I would counter that by saying the average size, dollar value size of the structure is much smaller than folks may think. Structures aren't appropriate only for your multi-million-dollar damages cases. It's really looking at whether it's a good opportunity for the facts of the case. People know, they've been around the block, they know minor, I need a structure offer. But it's not just minors. When you have those long-term damages that we can really show how our offer meets those identified damages, when you have all kinds of special circumstances, if you have a claimant on Medicare or Medicaid, it's even more important. So there's no case that's not worth considering whether it's going to provide some value for your mediation.
Exactly. Every case has a value, and, therefore, whether that value is high or low or somewhere in between, every case has a value. Your strategy might differ in terms of wanting to settle or, wanting to go to trial. But every case that comes across, defense desks or, claims managers' desks has some kind of a value. And usually that value is vastly different, especially in this day and age, from what the plaintiff's attorneys put on their cases. But just because of that alone, it's worthwhile investigating and seeing especially if you have a crazy demand, $150 million demand, and then you come up with a structure that, and the funding of that structure would be in the low 7 figures or even in the 6 figures, if that's the value that you want to put on the case. So I would say, yes, it's worth it in every case.
What about for jury trials? You've done jury trials before. When they're talking about life care plans and you have your expert up at the stand, would it be helpful to go through slides like this with us in front of a jury?
I'm not sure. I think every jurisdiction is different, but I'm not sure to what extent this would be permitted, in terms of explaining damages and explaining offers of things. And I also think that, juries have such a formidable task of fact finding and understanding, sort of digging the truth and understanding what the case is about. This is really the valuation bit that may not necessarily have them get a deeper understanding of what the offer, like what we're trying to do, right? Because at baseline, we're offering. And even though in a trial, we might present damages and say that we disagree with the valuation by plaintiff, we believe that, the plaintiff doesn't need this or needs less of this, and they don't need to change their prosthetics, every 6 months, and they don't need 7 different prosthetics. We might disagree on those things, but I think this is a little bit too, I guess, nitty gritty. If I were,
No, I'm just wondering if you would ever use some of these slides for use in counter inquiry when the plaintiffs are demanding for $100 million on a case. And
Sorry.
no, go ahead.
And I think a lot of the concepts of better visually presenting or evaluation of the case could be useful for a jury. It may not be directly expressed through a structured settlement in a jury environment just based on court rules, but the concept of, that we're rooted in here, sort of our core theme of using visual ideas to, I don't want to say simplify, because we really want to get to the deep level of detail, but to aid in understanding, to maintain that 7-second attention span. I think that aspect undeniably could be valuable. It just may be totally different, and the content of what we're presenting may vary.
Great. And now, Mary, thank you very much for your time. I think hopefully everyone finds some value in this presentation, and I will include in a link our contact information, as well as a slide here that shows that, so anyone can reach out to us to ask any other additional questions. Feel free to comment. Let us know your thoughts. Looking forward to it. Thank you.
Thank you. Thank you. This has been fun.
Thanks.